Hundreds of crypto investors relocated to the warmer climate of Puerto Rico in 2022, but they could not avoid the crypto winter. Time to hit the reset button. This is Taking Shelter. I'm your host, Peter Palsen. If you moved to Puerto Rico last year, how you prepare your 2022 tax return could have a big impact on your future tax exemptions. For a general discussion of the investor incentives related to Puerto Rico Act 60, see the video linked below. But essentially, Puerto Rico provides incentives or tax exemptions on gains to entice people to move to Puerto Rico. And U.S. tax rules related to bona fide residents of Puerto Rico can also exempt gains, and so you can end up with a zero tax on qualified gains. This video focuses on assets that you own when you move to Puerto Rico, which I'm calling previously owned assets. That is a determination I will discuss. For all of these rules, I'll give you my perspective, but I know it's not the only perspective, so I'm encouraging you to talk to your tax preparer. In this video, I'll discuss 5 topics. Number 1, how does U.S. tax law treat gain on the sale of previously owned assets? Number 2, is my crypto position a marketable security? 3, am I a bona fide resident of Puerto Rico in 2022, the year of my move? 4, when does my possession holding period start? 5, what questions should I ask my tax preparer for the 2022 tax year? Topic 1, how does the U.S. tax law treat gain on previously owned assets? Up front, I want to be clear that I'm talking about U.S. tax rules. For Puerto Rico Act 60 purposes, I have read several times that it is not possible to exempt gain under Act 60 on property acquired prior to moving to Puerto Rico. This is a Puerto Rico tax determination you should discuss with your Puerto Rico advisor. There could be some confusion because this is the general rule for U.S. tax purposes as well. No exemption for property that you own prior to taking up your residency. However, for U.S. tax purposes, there is an election you can make to obtain a partial exemption for these assets. You make the U.S. election by properly treating the gain in the year of the sale. There are 2 methods of calculating exempt gain when you sell previously owned assets while you're a bona fide resident of Puerto Rico. If the property is a marketable security, you use a cutoff method. If the property is not a marketable security, you use a daily allocation method. In both cases, the property needs to be of a type of investment asset specified in the regulations. Real estate and inventory assets are not included in this definition. It's also unclear to me whether some proof of stake tokens that are staked or loaned will fall into this category, considering the nature of some recent controversy in this area. Assuming we have a qualified investment asset, I'll illustrate the cutoff method by using an example of Bitcoin, which I'm treating as a marketable security. Let's say you bought a Bitcoin back in 2020 for $10,000 and you owned it when you started your possession holding period in Puerto Rico in 2022. Let's say that's on a date in January when the market price of Bitcoin was $47,000. $47,000 becomes your cutoff price, and you can only exclude gain when you sell to the extent your sales price exceeds $47,000. That's a big hurdle. But if you started your possession holding period on a later date in 2022, when the market price of Bitcoin was $30,000, then that's your cutoff price. And you can exclude gain on proceeds beyond $30,000. So using these 2 data points, the determination of when your possession holding period begins could increase your potential future U.S. tax exemption by $17,000 under this cutoff method. But let's say you did not qualify as a bona fide resident for any part of 2022, and you started your possession holding period when you woke up in Puerto Rico on January 1st, 2023. Then your cutoff price would be around $16,000 which was the market price at year end. Based on today's price as we record, you are already in the money when it comes to exempting gain. If your previously owned asset is not treated as a marketable security, you'll need to use the daily allocation method. Under this method, whatever gain is realized when you sell your previously owned asset is spread across your entire holding period. And the amount you can exempt is the amount attributed to the period after the start of your possession holding period. In this case, delaying the start of your possession holding period could reduce the days of allocation to Puerto Rico and thus potentially reduce the amount of future gain exemption. 3 points to make here. Number one, these rules are not optional. They're subject to definitions and determinations in U.S. tax law applied to your specific assets and your specific your specific facts and your specific investment assets. 2, in working out the calculations, you'll also want to consider how you allocate your basis and how you treat losses. You could have a combination of gains on marketable securities, gains on non-marketable securities, and losses. You'll also want to consider basis harvesting to put yourself in the best overall position. And number 3, as I'll note later, the basis recovery rules can be more favorable using the cutoff method than the daily allocation method. Now I'll address some of the definitions. Topic 2, is my crypto position a marketable security? As a reminder, to be subject to the pre-owned asset rules, you first need to have a certain type of investment asset, and not all crypto may qualify. We know from Notice 2014-21 that cryptocurrency is property, but as I said earlier, it's not clear that all types of cryptocurrency positions are included in the list of qualified investments referenced in the regulations. Exclusions from pre-owned asset rules could create a larger tax exemption. However, if your pre-owned asset is a qualified investment asset, your next determination is whether it is a marketable security, and that's based on whether it is actively traded in a public market. The idea is that the IRS wants to limit the use of the cutoff method to assets for which there is a reliable market price. Absent meeting that standard, you need to use a daily allocation method, which could be better or worse depending on your facts. Last year, the New York State Bar Association issued a report on the treatment of cryptocurrency under various U.S. tax investment provisions, including the one used to determine if a pre-owned asset is actively traded. These smart lawyers effectively concluded that Bitcoin and Ether should be treated as actively traded under the relevant rules. However, there are more than 10,000 other types of cryptocurrencies, as well as alternative forms of crypto investment, for which the determination is not clear. Furthermore, the recent FTX saga calls into question the reliability of the market pricing of certain tokens. This is a critical determination you need to make on an item-by-item basis. You'll need to consider for each type of crypto property you own when you relocated. Topic 3, how do I determine if I'm a bona fide resident in the year of move 2022? As I have mentioned, if you don't meet the bona fide residency requirements for any part of the year of move 2022, but you do meet them for 2023, you could get a cutoff price of around $16,000 for Bitcoin, assuming you can use the cutoff method. You probably already know that bona fide residency is a 3-pronged test. The first prong is a physical presence requirement, typically referred to as the 183-day rule. The second and third prongs prevent you from having a tax home outside Puerto Rico or a closer connection to a place other than Puerto Rico during a year. These latter 2 tests look to where you primarily work and play. The U.S. taxes its citizens on the basis of a calendar year, and the qualifications for being a bona fide resident is a test made for the entirety of the year. Thus, you might wonder how you can meet the tax home and closer connection test for the entire year of move, since before you move, you'll have a tax home in the U.S. and a closer connection to the U.S. The answer is that the rules allow you to disregard the first half of the year if you satisfy the tax home and closer connection test for all of the remaining half of the year. Plus, you still need to meet the physical presence test for the entire year. These tests are the reason many people move in the first 6 months of the year. But here's another rule that can often get overlooked. If you want to disregard the first half of the year move, the rules also require you to maintain bona fide residency for the following 3 full calendar years. I want to be clear here that the determination of bona fide residency is a year-by-year determination. So even if you don't qualify for the year of the move, you can still qualify or be a bona fide resident for following years. Has this ever happened? Yes. As a matter of fact, it's the outcome of 3 court cases focused on bona fide residents in U.S. possessions. Those are the cases of Bergensen, Vasquez, and Estate of Sanders. The rules have changed over time, but these cases still provide valuable illumination for evaluating the bona fide residency determination in the year of the move. They all reflect the gradual transition that occurs in a major move and the many factors that go into the determination. Topic 4. If I am a bona fide resident in the year of my move, how do I determine the start of my possession holding period? Whether you use the cutoff method or the daily allocation method, you need to know the starting date of your possession holding period. The starting date is defined as the first day of the year on which you are both, 1, treated as a bona fide resident of Puerto Rico for the year, and 2, you did not have a tax home outside of Puerto Rico. An example in IRS Publication 570 illustrates the IRS view of this determination using the cutoff method. In the example, Cheryl moves to Puerto Rico on March 1st and qualifies as a bona fide resident for the year of the move. She has a marketable security that she bought for $1,000 and held at the date of the move. The market price was $2,000 on March 1st when she's determined to have started her possession holding period because on that date she no longer has a tax home outside Puerto Rico. Subsequently, while she's still a bona fide resident, she sells the security for $7,000. According to the example, Cheryl can exclude $5,000 of the gain under Section 933, which equals the proceeds minus the cutoff price of $2,000. So even though Cheryl met the bona fide residence test for the entire year of move, the example concludes that her possession holding period only started on her actual move date when she no longer had a tax home in the U.S. This example is based off of Example 1 in the IRS regulations under 1.937-2. Both of these examples illustrate a taxpayer-friendly ability to allocate all of your basis to your pre-move period if you use the cutoff method. If you use the daily allocation method, your basis gets spread across your entire holding period and some would get allocated to your post-move exemption period. Topic 5, some questions for your tax preparer. To consider your situation, here are some questions you may want to ask your preparer when you are putting together your 2022 tax return. 1. Do I meet the requirements to establish bona fide residency in 2022, the year of my move? 2. What happens if I move back to the United States during the subsequent 3 years? 3. Are my crypto positions qualified investments subject to the pre-owned asset rules? 4. Are my crypto positions marketable securities? 5. When does my possession holding period start? And 6. If I'm not a bona fide resident for U.S. Section 933 for 2022, what happens to my Puerto Rican tax situation and my Act 60 contract? The last question is a matter for Puerto Rican tax advisor. However, I will note there's a coordination agreement between the U.S. and Puerto Rico that specifically provides that the U.S. regulations will apply to determine bona fide residency under the U.S. tax rules. While this provision doesn't mandate the Puerto Rican treatment, the agreement also affirms the desire of both parties to have consistent determinations. And it provides a formal mechanism to request competent authority assistance to the extent inconsistent views about residency or source of income create double taxation. In addition, IRS Publication 570 contemplates a situation where an individual is residing in Puerto Rico but does not qualify as a bona fide resident for U.S. tax purposes for the year. The IRS in the publication states that the individual should file a Puerto Rican tax return to report Puerto Rico source income, such as wages for services performed in Puerto Rico, and then file a U.S. tax return with worldwide income with a foreign tax credit for those taxes incurred in Puerto Rico to avoid double taxation. In closing, how you file your 2022 tax return, along with your Form 8898, can have a substantial impact on the amount of gain that you're able to exempt in future years. Given the changes in value of cryptocurrency assets in 2022 and their uncertain characterization, it's worth discussing with your tax preparer how these rules apply to your specific facts and circumstances from both the U.S. and Puerto Rican standpoints. If you found this video helpful, please hit the like button and subscribe. This has been Taking Shelter. I'm your host, Peter Palsen.